Welcome everyone to this late December or early December, but late year webinar. Thank you for joining us. This webinar arises from a discussion that Niran and Silva, with whom I am doing this today, as you can see, and we had a discussion about our perception that there was likely to be an increase in the use of ADR in business protection disputes, particularly in the employment field, and that many more of these disputes might in the future be dealt with by way of either arbitration and or mediation, or by way of hybrid litigation, i.e. ADR in conjunction with litigation. And this, in coming to this conclusion, we were drawing not only on our experience as arbitrators and mediators in the field, but as barristers appearing in these sorts of cases, but also in our sense that various trends were developing, and in particular in relation to drafting of contracts of employment and partnership or LLP agreements, and employment contracts. So the two particular accelerators or kickers of this change are in our view, first of all, United States law-inspired contracts of employment of senior executives employed by subsidiaries of American corporations, and then recent changes in arbitration procedures brought about by the Arbitration Act of 2025, which came into force in August of this year. We therefore thought that this was a good time to focus on this area. I will be focusing on these 2 points, the drafting and the recent changes under the Arbitration Act, and Niran will be looking at the nature of the arbitral process in general, but in particular regard to business protection disputes. So turning to the next slide, growing role of ADR. We very rarely hear, it struck me, of cases involving disputes between partners of law firms or LLPs or accountancy firms for that matter. Most are conducted within the confidential confines of arbitration. By contrast, it is more frequent for there to be litigation between, say, solicitors firms and their employees or associates, or as between solicitors firms in the context of alleged unlawful team moves. And this all, of course, takes place in open court, and therefore we're more aware of it. So question arises, why is it less frequent that arbitration is used for senior executives? And the background to the answer to that question is, of course, that many complaints between employers and their firms are dealt with in the employment tribunal, and by virtue of the statute, Section 203 of the Employment Rights Act, the jurisdiction of the tribunal cannot be ousted by arbitration provisions. That said, perhaps because of that statutory background, many firms do not include arbitration provisions in their employment contracts with senior executives, so as to be able to enjoy the benefits of confidential arbitration of these internal disputes. And let me say immediately that there's nothing in the Employment Rights Act of 1996 or any other legislation of which I'm aware, which prevents arbitration, or rather provision for arbitration in employment contracts, insofar as arbitration relates to pure contractual disputes of the sort normally heard in the High Court rather than the Employment Tribunal. And that's simply because Section 203 of the ERA bans provisions which preclude a person from bringing any proceedings under that act. It does not preclude common law contractual claims. And I should just say, for the sake of completeness, that includes contractual claims for wrongful dismissal up to £25,000 that may be brought in the Employment Tribunal under the Employment Tribunal's extension of jurisdiction order. These are simply not claims under the ERA and therefore not caught by the Section 203 prohibition. So, therefore, amongst many practitioners, there is the belief that there is likely to be an increase in arbitrations in relation to employment, high court style disputes. And this has arisen principally through, as I've outlined, the influence of drafting from the United States, particularly in relation to employees of UK subsidiaries of the United States corporations, of course, and usually to be found in their incentive packages, such as LTIPs or shareholder agreement or option agreements and the like. And then also, secondly, the Arbitration Act of 2025 may well accelerate the growth of arbitration employment disputes through particularly the new provisions in relation to emergency arbitration. So we'll look at that in a little detail. We'll also have a quick look at mediation as another form of ADR. And in particular, the court-ordered mediation. Another type of ADR, which is often used in employment disputes, is, of course, mediation. And the interesting development in this area is the idea of compulsory mediation, which has now become a real available tool rather than only some kind of voluntary encouragement for the parties. And the starting point is, of course, the Churchill and Merthyr Tydfil case, in which the Court of Appeal held that courts do have the power to stay proceedings in order to have parties engage in ADR, including mediation, provided that the order does not impair the parties' rights to a fair trial and is proportionate in all the circumstances. And then the DKH case on the screen is widely understood to be the first reported case in which the High Court of England and Wales actually used the new CPR powers. Those CPR powers followed fairly shortly after the Churchill case to allow courts to order mediation over the objections of a party. The court's reasoning acknowledged that mediation sometimes succeeds even when the parties are entrenched, and that it's beneficial to have the parties' fully pleaded positions considered in the mediation before trial. So again, this is a development of some significance. I'll now ask Niran to look at arbitration, what it involves in somewhat more detail.
Thank you, Selwyn, and good morning, everyone. As Selwyn said, I'm going to be looking at arbitration, first of all, starting with the very basics, what it is, but also explaining some of the strategic and practical issues in dealing with arbitration when compared to litigation. So arbitration is, as Selwyn says, a form of ADR where a neutral third party, called an arbitrator, hears a dispute and makes a legally binding decision in what's called an award. The reason parties will be in arbitration rather than litigation is almost always because there's been a pre-existing agreement requiring them to go to arbitration. So that could be a separate agreement, but more commonly in our context, it will be a clause within an LLP agreement or, say, an employment agreement. So just to be clear, it's different to mediation in the sense that the arbitrator makes a legally binding decision at the end of the process. It's not based on the agreement of the parties. But it's also different to court litigation, where the authority of the judge derives from the state. The authority of the arbitrator derives from the consent of the parties. And that's an important point, which informs much of the advantages, pitfalls, and certainly practicalities of dealing with arbitration. As I say in the second bullet there, arbitration is, in general, a confidential process. That is not absolute, as I shall explain on the next slide. Just want to draw one distinction between institutional, that's arbitrations. Those are arbitrations administered by an institutional body, and ad hoc arbitrations. So where there's an institutional arbitration, the clause will say something like this dispute will be arbitrated under the rules of, and will identify an institution, such as the ones I refer to there. I think for our purposes, the ones Selwyn and I have seen, generally they're clauses requiring arbitration under the rules of the London Court of International Arbitration, and that's what we'll be focusing on. But there are actually thousands of arbitration bodies throughout the world, but those are the most common ones probably for our purposes here. Where it's administered by an institution, there is an arbitration body with its own legal secretariat providing administrative support to the parties. There is a court that sits above the arbitrators, which can deal with issues such as the appointment of arbitrators. And there is a set of rules dealing with matters such as appointment of the arbitrators themselves and other procedural matters. Parties may not want to go through an administered process. They might want something quicker and more particularly cheaper. So they have a provision that requires them just to do an ad hoc arbitration. That simply says we'll have our dispute resolved by an arbitrator agreed between the parties without reference to an institution. In those situations, you don't have a set of rules. So parties often write their own rules or sometimes base them on the UNCITRAL rules that I've referred to there. That's an overview of what arbitration is. I want to say something about the advantages of arbitration for your clients in this area and also the limitations. One of the main advantages of arbitration is that the parties get to choose their arbitrator. They agree the arbitrator among themselves. And if there are three, there's a process for parties to appoint at least one of those. That's obviously quite different to the court, where you can choose which division you go in, but you can't choose the judge you get. And what it means is the parties can choose the arbitrator that they want, someone, say, with an expertise in this area. That might be, in our area, a lawyer who has expertise in restrictive covenant litigation, which obviously presents a set of legal issues which not all judges are familiar with. But equally, you could have someone who is a non-lawyer be your arbitrator. For example, if the area was broking, let's say, you could have an industry expert or some technical specialist with knowledge of the systems and data that are used. And actually that extends not just to the arbitrator, that extends to the representatives as well. You don't need a lawyer representing you in an arbitration. You could have a technical specialist, or you could have a lawyer and a technical specialist. The rules about rights of audience in the court don't apply. One commonly cited advantage of arbitration, is procedural flexibility. So the parties don't have the white book, which doesn't apply, doesn't have all the specific rules about deadlines and the like, and they can agree their own process. And they could agree a simplified process, something that's much simpler and quicker even than directions for a speedy trial. You could just agree parties disclose the documents that they rely on, or have very tight timetables, or even dispense with the final hearing, go to the trial, and have the arbitrator decide the case on the papers. Having said that, one of the disadvantages of arbitration over when compared to the court is the fact that flexibility. Arbitrators simply don't have the authority that judges have. There is a need to provide the parties with a fair and equal opportunity of being heard. And sometimes in focusing on that, arbitrators, perhaps unlike judges, let parties get away with conduct that a judge wouldn't. There's a concept referred to in arbitration called due process paranoia that arbitrators are said to suffer from. And that can mean it can be harder to get the other side to play ball when they're, for example, seeking long extension of deadlines and not complying with deadlines. Confidentiality is one of the main advantages, perceived advantages of arbitration. I draw the distinction between privacy in general, so it's a private process. Non-parties can't come to final hearings, but also the separate concept of confidentiality generally applies. Certainly under LCIA arbitrations, the parties undertake to keep confidential all the materials disclosed in the arbitration and the final award as well. Obviously, that's completely different to the court, where the principle of open justice applies, and parties can bump up against that when they're seeking to keep their confidential information confidential from competitors and the public. And also sometimes parties, even aside from confidential information, just want things to be private. They don't want their dirty laundry aired in public. But that isn't an absolute concept, as I said. It may be that there are separate proceedings afterwards between one of the parties to the arbitration and someone else who is not a party to the arbitration. And in those circumstances, in those proceedings, a court could order disclosure of documents created within the arbitration. Also, some other arbitral institutions, not the LCIA, don't have a provision that the final awards are confidential. Another advantage of arbitration is certainty. There's very limited scope for challenges to awards, as I shall explain further when I look at the role of the court. But there are limitations on arbitration when compared to litigation. I've already mentioned the issue of due process paranoia, but more fundamentally, being based on consent, the arbitration can only be pursued against a party who's consented to have the dispute resolved by arbitration. And that might be in the existing, pre-existing LLP agreement or the employment contract, or it might be that someone agrees in the course of the proceedings to be joined to it. But a new employer, for example, who might be wanting to be sued, might want to be sued for inducement of breach of contract, won't be a party to the LLP or employment agreement. And if they don't consent to being joined to those proceedings, would have to be pursued separately in the courts. Just a few words about the arbitration agreement. If you're drafting an arbitration agreement, or what's more specifically, an arbitration clause within an employment agreement or an LLP agreement, you can't really do any better than use the wording that's provided by the arbitral institution. So, for example, the LCIA has its own arbitration agreement standard wording that says any dispute shall be resolved under the LCIA rules by arbitration, which rules are deemed to be incorporated by reference into the clause. That is the safest way to have a matter referred to arbitration. There are other matters that can be covered in the contract that refer to the arbitration. Firstly, the parties might wish to specify the number of arbitrators, whether it's one or three. The parties may also wish to identify the seat of the arbitration. The seat of the arbitration determines the arbitration law of the arbitration. So if the seat of the arbitration were London, the arbitration law would be the law of England and Wales, specifically the Arbitration Act 1996. If the arbitration were in Paris, then it would be French arbitration law. But there are other provisions that parties need to consider carefully, both at times of drafting and also at the time of arbitrating, which will be relevant to the conduct of the arbitration. There might be a mandatory escalation clause. That's a clause that requires mediation before arbitration. There might be some contractual time bar for the bringing of claims that is shorter than the time limits in the Limitation Act. there might be provisions about how costs are dealt with of the arbitration. All of those need to be considered carefully. So what I'm going to do next is just do a short walk through the arbitration process under the LCIA rules. Again, we've chosen those because I think they're the ones you're most likely to come across. First of all, say there's really no substitute for reading the rules themselves. They are extremely short. They're in a tiny booklet, just a few dozen pages rather than the several hundreds that are in the white book. And I'm just going to highlight just a few key milestones in the arbitration process and just say a few points of those that are relevant perhaps to business protection disputes. The process is kicked off by the claimant filing a request for arbitration. The respondent then does a response. It's a very basic document, not like a pleading. Actually mainly has things like the addresses of the parties. But you also have to identify the claims and defences advanced. So that might be the contractual claims themselves, but it might also be that the arbitration agreement provides for other claims between the parties to be referred to arbitration, and those should be identified in this request for arbitration. May, in certain circumstances, affect the operation of the time bar clause on claims. An important part of the process is the appointment of arbitrators. Parties will choose their arbitrators based on experience, availability, personality, perhaps, but also particularly where arbitrators might be said to be chosen from a small pool, lawyers with specialism, employment lawyers with specialism in this area, or let's say specialists in the broking industry or the area of accountancy partnerships. Potential conflicts are very common. I'll just refer you to the IBA guidance, the International Bar Association guidance on conflicts of interest, which has various traffic light system of when parties should not take on a case or appoint an arbitrator because of a potential conflict, or where, for example, they just need to notify the other side of the potential conflict. It's a valuable guide to parties and potential arbitrators in this area. So I've said already how arbitration is founded on consent. I've said a number of times how you don't have the white book. So it's really for the parties at an early stage to set out the procedure that they want to follow. And that will be a timetable for evidence and statements of case that will involve the detail, for example, of what time on a particular day something needs to be filed, because you don't have that without the white book rules. But also rules agreed between yourselves about what you want to do about disclosure, which I shall come to on the next slide, and whether, for example, you need a final hearing. After that come the statements of claim, which are more like, might even say just like, pleadings in the High Court. Here you will articulate all the elements of the claims you've identified in the request for arbitration or response. So, for example, if there was a claim for conspiracy, this will need to have to identify all the elements of the test of conspiracy. Unlike in the court, evidence is filed at the same time the statements of claim are filed. So you'll need witness statements supporting the allegations of a breach of contract, so a breach of the duty of good faith and finality. You'll have witness statements and documents dealing with that, and expert reports. There isn't generally a separate phase for that. They're normally done with the statement of claim. So in the course of these statements of claim, which are statements of claim, statement of defense, maybe a response and rejoinder, there is a process of dealing with disclosure, or as it's called in arbitration, document production. The LCIA rules say almost nothing about document production. So what the parties generally do is refer to and follow the process set out in a different set of IBA rules, the IBA rules on the taking of evidence in international arbitrations. What that loosely does is set out a process for an applicant for a document to explain why the document is relevant and material, the other side to respond to that, either by producing it or by saying why they object to it, and then the tribunal making determination on that. It's almost always done on a table called the Redfern schedule. It's widely available on the internet. So there, just the one point to flag up is that there's a twofold test of entitlements to see a document, and that is relevance, that is helping to prove a specific factual allegation in the case, and materiality, which is a higher bar, which means a document is significant and necessary to reach the final outcome. So therefore you have to explain why it goes, for example, to the issue of reasonableness of the covenant or unlawful conduct. You then have an evidentiary hearing, which I think is slightly different to a trial in that obviously it takes place in a conference centre at the IDRC. It's a bit more informal, and opening submissions parties use PowerPoints, and you might have two counsel cross-examining the same witness, but largely it follows the structure of a trial with openings, evidence, cross-examination and re-examination, and sometimes closing submissions. And then after that, the arbitrator makes their award. So just a couple of further points. I'm not going to go through all of the items on there, but just I'm flagging up particular things that are worth reading. Early determination of claims is the one thing I'm just going to flag up, because there is a process for effectively what we might call strikeout, determining a claim can't be pursued or defence because it's outside the jurisdiction of the tribunal or manifestly without merit. Manifestly without merit under the LCIA rules is a slightly higher test, I think, than the reasonable prospect of success that operates in the court and actually has been introduced under a non-mandatory provision in the Arbitration Act. But I think only demonstrate it's quite a high test to effectively strike out the other side's claim and defense, or claim or defense. And indeed, most claims, a vast majority of applications for early determination on the ground of manifestly without merit fail, according to data published by the LCIA. So I'm going to move to something slightly different now, which is the role of the court in the arbitration process. So far as the Arbitration Act is concerned, just was amended earlier this year, but it's still the main piece of legislation which applies. Section 1 says this. I'm just going to look at the second and third bullets. The second bullet says parties should be free to agree how disputes are resolved, subject only to such safeguards as are necessary in the public interest. The court should not intervene except as provided by the Act. So here, that really says what is widely known, which is this is an arbitration-friendly jurisdiction. The court will generally let the parties and the arbitrator get on with how the arbitration is resolved, and generally avoid getting involved unless it needs to. So there are three main ways, which I'll cover, in which the court is involved before handing back to Selwyn. Firstly, in general terms, it supports the arbitration process. It can stay proceedings where, for example, there is an arbitration clause and the party said, I'm going to go for litigation anyway. You can stay their proceedings. Can also make witness orders, which of course arbitrators can't, because arbitration is found on consent, and witness orders apply where there isn't consent. They can also do other things to support the arbitration process, such as extend time or appoint arbitrators. I've asterisked a couple of the sections there because they are mandatory provisions in the Act. Not all the provisions are mandatory. The parties can contract out of them. I've mentioned already that awards can be challenged or appealed. This can be on the grounds of jurisdiction or serious procedural irregularity. And also, in some instances, there can be appeals on legal grounds, a point of law, but that is not mandatory. And that right of appeal on a point of law can be waived. And it is waived if you go under the LCIA rules. So I think that's counterintuitive to some people, that you go to arbitration dealt with by someone who's not a judge, and you don't have the right of appeal on a point of law. But that is the case, and that is really part of the attraction of arbitration to some, its finality. But even challenges on the grounds of jurisdiction and serious procedural irregularity, I don't want to overly simplify a whole body of jurisprudence, but they're quite difficult to grounds on which to challenge an arbitration award. And lastly, the courts can enforce an award. So, for example, if there's an award of damages made by an arbitrator, the courts can enforce that against individuals. And under the New York Convention, that can also be done against defendants who are based abroad. So I'm going to hand back to Selwyn now to deal with the Arbitration Act 2025 and some further matters.
Thank you, Niran. I should have mentioned at the outset that if anyone has any questions, you're welcome to use the chat function. I think we're quite well on time, thanks to Niran. So you please feel free to ask any questions you want to, and we'll try and answer as many of them as we can, or not, which, in other words, you don't have to. Now, the Arbitration Act of 2025, this had royal assent on the 24th of February 2025, and then its substantive provisions came into force on the 1st of August 2025. It applies to arbitrations that are commenced after that date, so it is prospective and not retroactive. There are many quite significant changes brought about by that act, but I want to focus just on the question of interim measures. And that is because I think everyone who practices in this field will know that a vital part of business protection in the context of employment or partnership, LLP disputes, is the urgent injunction, the need to get before a court quickly and to obtain interim relief to stop someone from stealing secrets or from joining a competitor or whatever. And generally speaking, the United Kingdom, particularly in London, has been very, very good over the years in developing procedures for really disposing at an early stage, at least of interim matters, granting interim injunctive relief in respect of restrictive covenants or indeed springboard injunctions, those sorts of forms of relief. So the question really is if, as Niran and I have been discussing, instead of going via litigation, wants the many benefits that Niran has mentioned in relation to arbitration, including in particular confidentiality, in particular professionals not wanting to launder their dirty linen in public, then what sort of provisions are there akin to those in the High Court for granting interim relief? And for those who had any doubts about this, the Arbitration Act of 2025 is an important milestone in the development of arbitration within this type of dispute. So as set out on the slide, and I am going to look at those specifically, the Act contains new powers for interim measures. Emergency arbitrators are now formally recognized in the Act, and they may make peremptory orders to enforce their orders. So, a bit like final orders or means of really enforcing orders that they've made in the course of the proceedings. And then, secondly, peremptory orders may be made by emergency order under Section 41A, and they are now enforceable under the same statutory enforcement mechanism as a full tribunal. Now, that is very significant indeed, that you can now obtain, for example, interim enforcement of a restrictive covenant or negative injunction type relief in respect of misuse of confidential information, and these are now enforceable as if they were made by a full tribunal. And through the third point, which is court powers in support of arbitral proceedings, for example, interim relief, this has now been clarified. They apply also to emergency arbitrators and not perhaps of ultimate significance in this area, but may be addressed to third parties, for example, freezing orders, although that does come up sometimes in this kind of dispute area. So these provisions taken together really have quite significant implications for employment and partnership disputes. It means that you can now, subject to what I'm going to say about drafting of the particular clauses in the employment contract or partnership LLP deed, is that you can now know that those sort of forms of interim relief, which are the hallmark of the High Court, are now available also within the context of arbitration, provided the underlying rules which the parties have chosen support that, or if they haven't expressly excluded those rules. So that formal recognition of emergency arbitrators and the enforceability of interim orders is, as I've indicated, a significant change. Why do these changes matter? The parties who need urgent asset protection or evidence preservation, they don't necessarily need to run to court first. They can rely on the arbitration framework if the arbitration rules permit the appointment of an emergency arbitrator and preserving thereby confidentiality and arbitral efficiency. So I think in the past, one sometimes had this problem that you might have had an arbitration clause with all the confidentiality trappings available to you, but if you need to enforce it, you need to run to the High Court, and that then, in most cases, will be an open court hearing, unless you're able to persuade the court that open justice does not require the hearing to be in open court. Just to make a more general point, the 2025 Act does not itself create a universal statutory mechanism to appoint an emergency arbitrator. Whether emergency relief is available depends on whether the chosen arbitral rules, whether they're institutional, as Niran pointed out, or ad hoc, that they provide for such an appointment. The Act provides enforcement powers and support, but if the underlying rules do not allow emergency arbitrator appointment, or if the parties have opted out, then the pre-2025 limitations remain. Why, perhaps an obvious point, do these changes matter for parties seeking urgent relief? Well, the parties now have greater flexibility. They can choose between court-based injunctions and arbitration-based interim relief, depending on urgency, confidentiality, and institutional rule availability. For commercial disputes, for example, involving assets, cross-border parties, and multiple jurisdictions, the strengthened and clarified interim relief regime under arbitration makes arbitration more viable and reliable for urgent accepted needs. Businesses and legal practitioners can plan arbitration agreements with more confidence, and knowing that the emergency interim tools are embedded in the statutory framework, provided the arbitration rules chosen by the parties support it. And it's interesting as well that when you now look, I haven't looked at all of the rules, but if you look, for example, at the rules of the LCIA or the ICC, that they make provision for very short time periods for, one, the appointment of an emergency arbitrator within 2 or 3 days of application to the particular institution. They are appointed, and perhaps more significantly, the time for granting of relief is also fairly limited. It's something like, let's just say, 14 to 15 days, depending on which system of arbitration you are deploying. So it looks, therefore, as though the news is good in terms of the interrelationship between the Act and the underlying principal rules of arbitration, for example, the LCIA or the ICC, to which Niran has both referred. So I now want to just look at a particular point, which is a favorite of mine, which has to do with cross-border chaos. It's not that I love chaos, but I do like to imagine that one can try and avoid it in some way. And I have perhaps just by coincidence or whatever, been involved in the 2 cases I want to just highlight for you, which show what can happen outside the arbitration process, i.e. normal litigation. And this is what is sometimes called the battle of the anti-suit injunctions. And this often arises, if it does arise at all, in relation to English employees of multinational groups, often American groups. And the key case here is Petter and EMC, which followed an earlier case called Semengo Turner, where the courts of the United Kingdom and Massachusetts were each asserting exclusive jurisdiction over an employment-type dispute. The Massachusetts courts said that they had exclusive jurisdiction under Massachusetts law, which had been chosen by the parties under the stock option plan, which was the document at the center of the dispute. And EMC sued Petter in Massachusetts, and Petter in turn sued for declaratory relief against EMC in the United Kingdom to say, well, they did notwithstanding the exclusive jurisdiction clause in the stock option clause, the Massachusetts court had no jurisdiction. The UK court based its exclusive jurisdiction over employment disputes under the then Brussels recast. So here you had 2 courts, each asserting exclusive jurisdiction, one as a matter of contract and the other one as a matter of statute, and each granted an anti-suit injunction against the other party from proceeding in the other jurisdiction. I mean, this is chaos. And not just chaos, but expensive chaos, because you're needing to run 2 cases in 2 different jurisdictions. And not just that, but the speed with which things happen, each court trying to grant injunctive relief against effectively the proceedings in the other court, it leads to I would say a quite unfortunate spectacle of different courts going head to head against each other, each asserting their own jurisdiction. So that's one example of cross-border chaos, which is exists within the litigation framework. Another one is disputes over the system of law which applies. Now, here you had in Duarte and Black and Decker. Duarte was employed by an English subsidiary, I should say, of a Maryland company in an LTIP, a form of incentive agreement that contained restrictive covenants that were subject expressly, choice of law, to Maryland law. The English court decided that that English public policy required English law principles of restraint of trade to apply. I mean, strangely enough, in that court, the court also held that decided the matter under Maryland law as a kind of backstop. But effectively what they held is they weren't interested in whether this very long restrictive covenant and wide restrictive covenant was enforceable under Maryland law in relation to litigation in England with an employee domiciled here. English public policy, particularly Article 16 of the Rome Convention, in force at that time, that meant that English public policy overrode, let's say, looser rules of restraint of trade in Maryland. It so happened that the court held in our favour that the covenant was unenforceable, whether under English law or Maryland law. So to that extent, the point was academic. But the important point that I make about this is that arbitration seems to be the only way to avoid these type of disputes. Arbitration and the agreement can provide for a consistent dispute resolution across the jurisdictions. And this is quite important for all of you who practice in an area where executives are now geographically dispersed, where the lawyers are geographically dispersed. The idea of not having these arguments either about jurisdiction or which system of law applies is very attractive indeed to the parties. So I'm then just going to look at arbitration clauses in employment contracts. I think I've already prefigured some of the points that I'm going to make, but one of the points I think I've already made about drafting of clauses, particularly in employment contracts, is that one has to be very careful to make sure that your drafting clearly does not go into the forbidden zone of appearing to exclude employment tribunal type claims. And that can be done whether positively or negatively, positively stating what kind of claims are covered by the arbitration clause, contract, and wrongful but not unfair dismissal claims, and also specifically saying that this clause does not apply in relation to disputes under the Employment Rights Act of 1996. So the advantages for senior executive disputes, I think we've already to some extent covered that. In particular, Niran mentioned a number of points, but the idea of confidentiality is a very significant one in today's world, particularly with the way in which news transcends international barriers via social media and the like. And in relation to restrictive covenants, this is typically and quintessentially an area where you could have arbitration provisions, and where, as I say, the doubts that you might have had about interim relief are now resolved, so the benefits can be enjoyed of arbitration without worrying about whether you can get the kind of immediate relief that you wanted. I should just make one point that occurred to me, and that is that although the rules I referred to of the ICC and the and also the LCIA talk about a decision within 14 days or so, I think one would often have to prevail upon the arbitrator perhaps to be a little quicker than that, and given that in the employment sphere in the High Court often judgments are given almost immediately. So if there's a competition there between arbitration and litigation, I think that the arbitrators might want to speed up things. Then just a few practical takeaways. There is now, Niran and I believe, all the more reason to choose arbitration as a way of resolving disputes, not just in partnership LLP agreements, but also in employment contracts with senior executives. In order to do that, this needs to be planned with your clients, planned in terms of the making clear what it is, what kind of disputes will be covered by the clause, in particular ones that work under UK law, and also ones that where the underlying rules work in tandem with the beliefs and wishes that the clients have, particularly in relation to emergency relief. You need to just make sure that your drafting encompasses the powers that are now given, either by default or certainly by not excluding them. When one is involved in disputes of the kind that one gets in this area, then there's obviously an important need for the clients and their advisors to coordinate ADR and litigation at an early stage. It may be that you decide that you do want to go to court to get an injunction and then do the arbitration. You can do these things in tandem. Often in the past, certainly people have gone for injunctive relief, to not just to protect themselves, but to establish a strong position for the arbitration that may follow. And of course, mediation also has a role. I've often felt that mediation is a little underused. Once you've got a restrictive covenant injunction in place, and the speedy trial has been ordered, that is a perfect time for a mediation to take place to try and resolve the matter, bearing in mind that mediation can give solutions that you cannot get within the court, for example, reduction of the period of a restrictive covenant. So preparing clients for the process. And our last somewhat cri de coeur is stay ahead of reform. This is an area which is developing, and one needs to be aware of what is going on. And I think that's all that we wanted to say by way of our presentation. And if there are any questions that anyone wants to ask, then please do put that into the chat.